Good evening, ladies and gentlemen. First of all, my apologies for running a little behind. My name is William McCarthy, and I'm the acting chairperson in Mr. Marnick's absence tonight. And we have two cases on for this evening, two public hearings. The first in case number 1999, which is continued from January 21st of 2015, and case number 2000. We'll first take up case number 1999, and this is a public hearing on case number 1999. This case involves the application of Thomas and Suzanne Lowenson for a special permit as set forth in Mass General Laws, Chapter 48, Section 6, under Orleans zoning bylaws, Sections 164-3C1, parens B, 164-21A, Note 3, 164-23, and 164-44C, to modify and reconstruct parts of a pre-existing non-conforming single-family dwelling in violation of lot size and rear and side setbacks, and in the alternative seeks a variance. The property is located at 189 Skakit Beach Road, Orleans, map 23, parcel 17. Attending on behalf of the board are the regular members Beth McCartney, Rolf Soderstrom, and myself, and associate member Mr. Peter Jablon, and also board secretary Sandy Stewart. Also in attendance is the building commissioner of the town of Orleans, Brian Harrison. I should first ask, are there any members of the board disqualified by reason of a conflict of interest prohibited by law? Hearing none. Excuse me. And have any members of the board communicated with the applicant or any interested parties? Hearing none. I would note, I guess, at the outset, as is obvious, that there are 4 members present, and under the rules of the need for 4 votes in the affirmative to grant relief in an application, that would recall all of us. And I presume you wish to proceed and may want to reserve your right to poll the board, or?
I would, Mr. McCarthy, if you don't mind, I would ask that the board hear our presentation and ask whatever information it's looking for, and then that's fair to poll the board. And if there are not 4 affirmative votes, I'd like to reserve the vote for requesting continuance for a second.
Understood. Let's see. With that, I need to find my oath. Do all persons intending to testify solemnly swear or affirm that the evidence that they will give at this hearing before the Zoning Board of Appeals of the town of Orleans shall be the truth, the whole truth, and nothing but the truth? Okay. Let me just get my correct case files in front of me here. And Mr. Zender, if you probably would like to proceed.
Thank you, Mr. McCarthy. Good evening, members. Again, my name is Ben Zender, and I'm here with George Cummings, who is the principal architect for the project, and also in the audience is David Little from Ryder Wilcox, who prepared whose firm prepared the certified plot plan. Just to make sure that the board is operating with the right materials, the submitted materials consist of a series of floor and house plans prepared by A-Line Architecture. And they're lettered in the bottom right-hand side. The sheet number is A1.1, which is the first floor plan and proposed first floor plan, existing and proposed. A1.2, which is existing and proposed second floor plans. A1.3, which is the existing and proposed footprint. And I'm just kind of nothing I think you need to really. Okay. Sheet A3.1, which are proposed existing northeast and northwest elevations, and A3.2, which are existing and proposed southwest and southeast elevations. And there's a site plan prepared by Ryder Wilcox that's annotated by A-Line, which is dated 12/22/14. And then today was filed with you an A-Line architecture plan which in the lower right-hand corner is marked S1.1 small a, and that is the most current site plan. And for the board's information, the only difference from a site standpoint between the Ryder Wilcox site plan and the A-Line Architecture site plan is that on the Ryder Wilcox plan is an existing shed that's shown on the plan, and the plan was modified for the purpose of presentation with the Conservation Commission to remove the existing shed and replace it with a smaller shed, which is shown on the A-Line plan on the southern side of the property. So the only difference between the two plans is that the existing shed is being replaced with a smaller shed. And that actually reduces the lot coverage to 14.7%, where it originally was 15.5%.
Is it, may I ask you, is this in substitution of what was S12?
Yes, it is.
Notwithstanding what you just said, it looks to me a lot more different than the original.
Hold on, let me just-
I'm just wondering what,
George, the difference between S1.1 and S1.1A, are there any differences other than substitution of the shed?
No, it's just in
so maybe
information.
we're looking at the same plan, right?
Yep.
That one is,
Yeah, we have
that one there,
we have an S1.2
yeah,
also.
that one is the one that just indicates where the setbacks are.
Okay, yeah, S1.2 is just a building envelope plan showing the proper zone setback.
Yes,
Okay.
that one's still part of the presentation.
So was there a prior S11?
It wasn't S1.1, this was presented previously.
Yes.
Yeah, there was an S1.1 previously.
But I don't think we got
I
it.
don't think we got that.
Okay, well, then-
Hence my question.
And S1.1A is the architect's plan of record for the site.
And just as a, only because I think it's atypical, the relationship of the Ryder Wilcox certified plot plan and the site plan, they mesh together and,
They mesh together other than the location of the shed.
Of the shed.
S1.1A shows the removal of the existing shed and replacement with a smaller shed on the south side of the property. Again, reducing the footprint a small amount.
all right.
I'm going to, if you don't mind, I'm going to ask Joy just to describe for you the proposed. I don't know if the members had a chance to go out there and look at the property. I know it's very snowed in. It's difficult to maneuver around the site.
I drove by, is it okay to answer? I drove by there, and the houses are all clustered together and hidden by trees and such,
Yes.
and a narrow road. So I got an idea of what's going on there.
I saw it when it was on the market, so.
Okay, thank you. I just noted for my own personal
Yeah.
purposes, when I went to look at the property, I was up to my knees in snow. Trust me,
Yeah.
I did.
No, I
So
saw it prior to
It's
that.
difficult.
Yeah.
But I think it is important for the board's consideration that they understand not only what the house looks like now, but its relationship to Escaped Beach Road and also its relationship to the property's impact. So with your permission, I'm going to ask Joy just to describe very briefly what the proposed alterations are for the house itself. And that, I'm going to preface that by saying this was approved as presented to this board tonight by the Conservation Commission yesterday morning without conditions. So.
Yes, unanimous vote in favor of the project as proposed and as depicted in the most recent site plan that you were given, which you might want to refer to first, because it describes pretty much what we're attempting to do, which is to remove the parts of the building, with the exception of the masonry chimney, from over the property line, so that it is at least within the confines of the property. The project involves the removal of the status of an attic bedroom that it does not comply with the current building codes. It doesn't have an egress or a proper ceiling height, so they're going to recommit that to attic space and make another second bedroom and a small study that they will walk through to get to the second bedroom on the south side of the building. And they will add a small entry porch, covered porch, and a section of the building that connects the original building with what's being proposed. There will be a roof deck. Because we weren't really able to put any deck space out in the yard because of the Conservation Commission's restrictions. We're moving the shed, as Ben said, and relocating it to be out of the resource area and also behind the setback line required by the zoning board requirements. Anything else I need to say?
If you could just briefly, just what are the square footage of the floor area?
The present livable square footage of the house is 832 square feet. The proposed square footage is 1,020 square feet. The maximum footprint of the existing house is 12.9%, which is 898 square feet with the shed, and the proposed footprint area will be 1,031 square feet, which is 14.7%. So we no longer exceed the footprint. It's nice.
Could you repeat, it was 890, and then, what were those two figures you just,
Existing
898?
footprint area is 898,
okay,
12.9%.
okay,
The maximum allowable is 1046, which is 15%. And the proposed footprint area of the new 6x8 shed is 1,031, which is 14.7%.
thank you.
And I think the members who had a good look at the property will note that it backs up to a large parcel of undevelopable land, mostly wetlands, when you're at this property, the only real view of this property is from Skagit Beach Road. You know, it doesn't there's the way it's constructed, or the property to really to the west. It's in the back. It's wooded. It's not really visible in any respect other than over the fence, looking from Skagit Beach Road, and it's a very small addition. It's essentially staying within the footprint of the house, but removing some encroachments.
Ask,
So,
then, with that change, you're no longer exceeding the 15% lot coverage requirement, so you would not be seeking the relief
no,
for that.
it would be compliant with that. So or relief to alter the non-conforming structure with regard to the sideline setback requirements. And again, we're staying within the footprint of the existing structure, essentially within that structure, and removing some of the encroachments.
These areas are, they are additions.
Yeah, I'm sorry.
They're moving into the side.
Yeah, on the setback on the Skagit Beach Road side. So we're here to answer any questions.
Would you speak up?
I'm sorry.
Yeah, people can't hear you.
Oh, I didn't know. I wasn't
Yeah.
watching them. So we're here to answer any questions you have, and I do know that Attorney Reed has submitted a letter in the form of a legal opinion, and I would like to reserve the opportunity to address those concerns after Attorney Reed has a chance to speak.
The only other thing I'd like to mention.
Just speak up.
The only other thing that I'd like to mention is that the Board of Health requires that the house be upgraded to include a full bathroom, which does require an addition in order to be able to be compliant.
Yeah.
And in so doing, I was trying to be respectful of the setbacks and the zoning board restrictions, and mask the building accordingly by having two small bathrooms that might function rather than one larger one, but they both are compliant with the Board of Health requirements.
So if I understand, the juxtaposition is that you need zoning relief to accommodate the bathroom, and you need the bathroom to accommodate the Board of Health
Exactly.
in order to get a
It's little
building
attachment
permit to do this.
Mhm.
Okay. Can I just add, you mentioned at the outset about moving the footprint, and it's perhaps not pertinent to zoning, but is it still encroach over the lot line of the abutting lot line in a corner?
There's one remaining encroachment, and that's the masonry chimney. If you look, looking at the plan, the building presently encroaches at the southerly side of the property. It's probably easiest to see if you look at the Ryder Wilcox plan.
Is it the corner below the red?
Yeah, the corner below, that's being removed so that the building no longer encroaches on the neighboring property. But there will remain an encroachment. If you look at the portion of the building above that, there's a small portion of the chimney that encroaches, a masonry chimney that encroaches that will be retained.
Oh, I see. Looking at the color legend, the gray dots are to be removed. Okay.
Yeah, exactly.
Let's see. Back to my script for a second here, and I guess procedure. This would be the appropriate time to take questions from members of the board. Beth, would you like to start?
I'd rather hear from the attorney and get all that. I don't
Oh,
really have any
Ed, had
questions
you
at this
finished?
point.
For now, I'd just like to reserve to answer any further questions and also to
Yeah.
address Attorney Reed's, positions after he's had a chance to express that and address board questions.
I would as well. I would just be able to
Yeah, thank
have a
you.
moment to read it before we...
Yeah.
Well, then I guess I'll open it up to anyone who would like to ask comments, questions, or make comments.
No, I'm good. I'm waiting to hear the attorney's Reed's presentation, and that's it.
That'll be part of the public commentary for in favor and opposed. Rolf?
The question I have is, how long has Joyce Cummings owned the property?
Well, Joy doesn't own it. The Lowens
Oh.
have owned the property, and it's been in the family for many years. Tom Lowens owns it now, is a child of one of the Lowens owns, and so I'm going to piggyback on Attorney Reed's presentation, but
1996.
There's a deed in there somewhere.
yeah, I believe it's 19. I can't answer the question.
Oh, okay, so it's
But it's been
owned for quite a while.
Yeah, it's been quite a while.
That's the
yes.
point I was trying to...
Yes, it has been. Yes, and Mr. Lowens' intention is to try to keep the property in the family. It's one of the reasons why he's doing this.
Okay. I don't think I have any questions at the present time, so in that case, we open up the meeting to ask if, actually maybe one question asked is, have there been meetings or consultations with butters, neighbors relative to this?
Yes. I have had some discussions with Attorney Reed to see if we could resolve the differences here, and we've traded back and forth some proposals for some mitigation, et cetera, which certainly, again, if Attorney Reed is kind of looking for some of these forms of mitigation, we're certainly willing to do it. Some of the things that we've discussed have been a fence on the boundary line, making a solid rail out of an open railing on the upper deck, and at the rear, and also some other things, some of which we're fine with. But I didn't, again, if we get to a point where the board's looking for some conditioning or some mitigation, I think that's something we can certainly talk about with the board, with the assistance of Attorney Reed as client. So we have had some conversations.
Okay, thank you. In that case, are there any members in the audience who wish to speak in favor of this petition? Any members wishing to speak in favor? Hearing none. Any members in the audience wishing to speak in opposition?
Good evening, Mr. Chairman, ladies and gentlemen, I'm Attorney David Reed. I represent Carter and Lucy Buckley, who have a home at 157 Skakit Beach Road, but they also own the property which is immediately behind this home, the property on which the current structure encroaches. Their property is currently undeveloped, but I wouldn't characterize it as undevelopable necessarily. And that's why they are here to protect the future options for their property in the event that they should choose to seek to develop it at some time in the future. Because if they don't speak up now, it's going to be too late when and if that happens.
It's an undeveloped presently?
It is undeveloped presently. It has a number of bogs, some overgrown, but it also has upland that potentially could be developed.
So
Whether it will be or
it's
not,
this parcel here?
yes, the large parcel behind it.
So it's the southern side of 189.
Yes. So, west of there, I guess. Behind the house. Let me if I may just address a few comments about the proposal itself and then get to the legal issue that I raised in my letter to you late this afternoon. And I apologize for that coming in so late, but it actually only developed in terms of my understanding of that sequence of events just today. If I had the opportunity to get that to you earlier, I certainly would have tried to. And I did provide Attorney Zander with a copy of that letter at the same time it was sent to you.
May I ask then, with respect to the comment about prior discussions, did they precede today?
Yes,
Okay. But the issues presented in the letter arose subsequently?
yes.
Thank you.
With respect to the proposal itself, first, I think, even though they no longer are asking for the variance, I think they've actually cited to you the wrong section in terms of the relief that they needed for the lot coverage. It may be academic, because they reduced the size of the shed and therefore kept below the 15%. But I don't think 164-21 footnote 3 that they asked for in the application is the correctly applicable provision to a residential home. I think it's actually footnote 5 that applies to single family. But that's a little bit more elaborate, but again, if they are able to stay below the 15%, it probably doesn't make any difference to your deliberations this evening. It's true that on the site plan, they are going to remove a portion of the building that is currently encroaching on the Buckley's property, and are moving the replacement structure a little bit further back from the property line. But since I'm pretty confident that none of you got out to the back side of that building today, and in fact, I haven't been either because of the weather, just to put it in context, the piece that's over onto the Buckley property now consists of a fence enclosure for an outdoor shower and the corner of an open storage area, each of which is only 6 or 8 feet tall at most. What's proposed,
The gray sections again, that's on the... Okay.
that corner. What's proposed to be now as little as 1.3 feet from our property line is a 23.5-foot tall building that will now have 2 stories of living space, not just these accessory structures that are on the property. And there's a significant difference. And while it's appreciated and necessary that to remove the parts that are on the Buckley property, which never should have been there, obviously, in terms of the assessment of the impact upon this development on our property, it's not just a benefit to remove those small sections, but it is, from our perspective, a significant detriment to replace them with a much bigger and much more active structure. I think, frankly, the whole project is unworkable. As I think Chairman noted or had discussion about in the part of the presentation from the applicant, you can't even walk around this building. You can't walk, at least not on their own property. You can't walk in a clockwise direction because the building comes right to the property line and a piece of the chimney actually comes over it. And as proposed, the rear door to the addition is going to be 1.3 feet from the property line. Obviously, they're not going to have a screen door on the outside of it because you can't open it up without doors over onto our line. And if you look at the architectural plans, they propose to have what looks like 2 steps coming down from that door, that rear door, step and a landing. And I'm looking at A3.2. The side profile for that rear door is here. And the steps coming out are here. Appear to be about 3 feet out from the building. There's only 1.3 feet before you get to the property line. And unless you're very slight of stature, you're not going to be able to walk around that corner without going onto my client's property. It's just unworkable, let alone the practical difficulties of trying to construct this structure without going onto my client's property. Even if they can achieve that, the resulting building is just unworkable. You can't get out of that back door and go anywhere except onto my client's property. The proposed
Given,
roof deck,
given the 1.3 foot,
1.3 feet between the edge of that building and the property line. And that 1.3 feet is, as Mr. Zender pointed out, probably best visualized on the Ryder and Wilcox plan. There is an insert on the left side that shows the details of the setback. Lower right-hand corner. As you can see, the proposed building, which is the darker gray on that version, is 1.2 feet on one corner, 1.3 feet on the other. And if you look further over to the existing building, it's 0.5 feet at the next corner you get to, and a maximum of 1.5 feet at the furthest corner. And in between that, the chimney actually comes over onto my client's property.
since it was my understanding that the only property line encroachment was to be removed, could you indicate on where
This-
that chimney you're talking? Oh, is that the back of the existing dwelling?
Yes.
Okay.
Yeah.
Okay, I see.
And again, that's also shown in more detail on the insert in the lower.
Yeah, that's,
Yeah.
I needed to go to there first. Okay.
And also, if you can look at the elevations and look at the plans, between the two, if you will, L's of the building, that middle section is proposed a roof deck. The existing roof is only just over 10 feet tall. So they propose to have an open roof deck, railings on the did indicate that as we had, could become a solid wall rather than an open rail. Either way, I'm sure it's going to be a very popular spot.
This is this area?
Yes. If I understand the plans correctly, what's now a slightly pitched roof is going to be made flat, and a roof deck built on top of that. That's what it appears to be. I'm sure that's going to be a very popular spot. They look out towards Skated Beach and beyond that out towards Rock Harbor area. It's going to be up 10, 12, 15 feet at eye level above the, probably 18 feet at eye level above the roof line of the property. It's going to be a nice view, good place to have a picnic, a party at night, and a cookout. But from my client's point of view, if we're ever to develop our property, that's going to be a real nuisance. 1.2 feet from our property line is an open deck living area, 10 feet up above the ground level. In terms of the necessity for this project, it's my understanding, and I'm sure Mr. Zender and Ms. Cummings can correct me if I'm wrong, that the Board of Health said was not that they had to do these renovations to have an indoor shower or bathroom. My understanding is what they said is in order for this property to be rentable, they had to have an indoor shower, which it presently does not have. All it has is the outdoor shower stall. At no time have I ever seen anything that said they had to have two bathrooms, which is what this addition proposes. One on each floor. From our perspective, this addition is going to be substantially more detrimental to my client's property and to the neighborhood in general, because it's putting a significant addition on a very small house, on a very small lot, right on the property line for all practical purposes. I can't think of a case where I've seen less setback on any house than this in my career. To put it in perspective, as I believe the information provided by architects in the summary of calculations, which was done predominantly for the Conservation Commission, because they have more volumetric measurements than you have. But in perspective, this is in terms of the volume of the building, and therefore in terms of its utility and probable occupancy. It's increasing the volume of the building by 43%, almost half. Again, what's there now? While it may numerically be small, proportionately it's significant. And we would urge you not to approve this kind of addition on such a small lot in such proximity to my client's property.
May I just look with reference to this map? This is your
Yes.
client's property, has entirety bounded that?
Yes.
There.
How many acres are there?
I don't recall off the top of my head.
Over 6 acres.
6 acres.
6 acres? Okay.
But the upland portion is nearest to this boundary. It's potentially developable piece.
Okay, so
Go ahead.
I couldn't see, this right here is the property that your client owns?
Yes.
Okay.
Everything
If you match up the
southwest
shape of that, it's sort of that
Okay.
way.
Do you have any engineering showing the building envelope for this site?
No. And I don't want to misstate it, they have no present plans to develop it, but if they have that in the back of their mind, as they do, they have to speak up now to anything that they believe is going to jeopardize that potential. And just think of it now, it's very close as it is. But the purpose of setbacks is to provide separation between buildings, for privacy, for quality of life reasons, for noise reduction, for light mitigation. If their property is, for all practical purposes, right on our lot line with none of its 25-foot setback that's supposed to theoretically have, then even when my client complies with the setback, they're still much closer than they should be to this building because of its non-compliance. So my client's development potential, at least in terms of the quality of its development potential, is severely minimized by this existing condition and this making it worse by doubling the height, more than doubling the height of the building and the size of that end. So we are gravely concerned about that impact on that property.
Can I ask where the means of egress from a public or private way is to that? It may not show on the scale of this, but
There are, I think I have a land court plan of that property. That's the, if I may approach.
Commissioner, please.
That's another picture of the
Mhm.
assessors map, and it's this whole piece here. It has, remember this road is here, and there's another road coming this way.
Wildflower Lane.
So out of the 6 acres, how much is upland?
Very little. But the upland that does exist is right behind this house. So here's the land. This is the plan of record for their property, which is parcel 1 here. Most of it, as you can see, is cranberry bogs. But the only upland piece is right along behind their house, which is on this piece, and then going down towards the beach. The greatest potential for development is coming here and get right along in here. So that's right behind them.
This is parcel, then this is...
May I ask, since Attorney Zender's going to reserve his right to comment on it, but rather than taking everyone's time for me to read your correspondence, aside from the general argument about why your clients oppose the proposed project, whenever I see a lot of case citations, I'm curious what the gist of your letter.
Sure. The thumbnail version, the Reader's Digest version of that letter is that if you look at the first 2 exhibits, the plans, you can see that on what's exhibit number A, the locus that's before you is actually made of 2 parcels. They're labeled parcel 1 and parcel 2.
Exhibit A to your correspondence?
Yes. That's the plan of record for the locus.
I'm not sure I see it. I'm going to take it it's the first 2 of these, okay.
You can see it's actually 2 parcels, one to the northwest part, which is the bulk of the property, and a smaller one on the southeast side.
Mm-hmm.
Both of those were originally part of the property that is further to the southeast. That's what, if you look at the second plan, you see a 1928 plan of Marguerite Oliver.
Mm-hmm.
That was the larger piece out of which came these 3 pieces. The house at 185, the house at 189, and the little piece in between, parcel 2 on the plan. Does that kind of, the one's reversed from the other, so they're kind of hard to go into, but
So the 0.56 acres is the subject site of this case.
that was the last time all three pieces were in common ownership, as far as I know. With Marguerite Oliver. And then she conveyed out the bulk of the current site, parcel one, the large part, to the Broomsmith. In 1964, her heir, her husband, or widower, also conveyed to the Broomsmiths what's shown on this plan as parcel two, where the current building overlaps onto what was at that time his property.
And what was the year of that?
1964 was that second conveyance.
The second conveyance, okay.
And I would guess that it was done either to accommodate for this overlap or to permit it, one or the other. I don't know which came first. The assessors' records indicate that the house was built in 1950. I don't know if there were any additions after that, but it may very well have been just to justify or to correct the fact that the house overlapped onto the Oliver property. The problem is that in 1964, zoning had already gone into effect and required 20,000 square feet per house lot for residential use. By conveying that parcel two from this piece, it rendered this piece less than 20,000 square feet and reduced its size even further to just under 17,000. That was a violation of the zoning bylaw at the time.
In force at the time?
Yes. And as a result of that, it also places this property in jeopardy, because this property is the beneficiary of that piece that should never have been severed, and in fact is dependent upon it for the existence of their house. So both of those lots, by virtue of that 1964 conveyance, have lost their protected grandfather status, and neither is currently a legally pre-existing, non-conforming property. Either, in my opinion, could now only be altered other than routine maintenance and repairs by variance because of that 1964 conveyance.
Ask a question? Mr. Reed?
Yes.
And that, what you just described, is called infectious invalidity?
Correct.
Okay.
The original lot from which the piece was taken
Mhm.
is rendered invalid, is the term often used by the court, to confuse it with non-conforming. Invalid, because it was already a substandard lot and it was deliberately reduced further by something in the order of 2,100 square feet. I have it's an irregular shape on the piece that was.
I see it.
approximately
That's
2,100.
clear. Mhm.
But because of the doctrine of infectious invalidity, not only is the, if you will, donor lot rendered invalid, but the recipient is also invalid because it's relying on property that it shouldn't have. Sort of like if you think of a person who's charged with receiving stolen property. They didn't steal it, but they're the ones that got it and they're not supposed to have it. Well, this lot is not supposed to have that extra 2,100 square feet. It should never have been
got it.
conveyed.
Irrespective of whether the beneficiary lot was lawfully nonconforming at the time?
Yes. Because it's using it now, it's dependent upon it. You can't give it back because the house is on it.
And these were not, pardon me, these were not in common ownership at the time?
No, they were not. They were, as indicated, it was family and relatives of some degree, and had been apparently all along since Marguerite Oliver's ownership, but not in identical ownership such that it would jeopardize them if they were vacant lots, for example.
Okay. I appreciate that thumbnail. Anything else you wish to say at this time?
No, I think that covers it, but the result of that is that it's not eligible for the special permit, in my opinion, and we would need a variance for everything they want to do up there. Because they no longer have that grandfathered status.
Except for routine maintenance.
Yes, maintenance and repairs, maybe not. And in fact, I believe, not to suggest the alternative, but if there were a catastrophic destruction of the building, it could be rebuilt.
Sure.
But other than that, no volitional increase could be done other than by variance.
I don't think, is there anyone else, your clients wish to speak also, or are you speaking on their behalf? Or?
Do you have anything else you wanted to say? No. I think they're all set. Thank you.
In that case, Mr. Zinder reserved his right to comment on your presentation, and I don't think there's anyone else in the room who, unless there is, who wish to speak, will return.
Can I ask Brian a question?
Sure.
Brian? Did zoning start in 1964?
I believe so. I don't have that date in front of me. 1954, I believe.
1954?
Yes, sir.
And pre-existing lots would have been,
Pre-existing lots would have been grandfathered at that time because there was a generous grandfathering provision in Orleans in the early days. As you remember, the case of York versus Rothman, there was a lot of discussion about that. But both these houses appear to have pre-existed before zoning, so there was no vacant lot issue for either one of them.
well, you've got 15,000 square foot lots that are obviously pre-existing non-conforming.
Right.
And the fact that they added land to this after 1954 is what you're saying makes it in violation.
It's not that they added land. It's that they took it from another undersized lot and added it. If they had taken it from my client's property, if we conveyed them a piece, it made their piece less non-conforming, that would have been fine. But to take it away from another developed lot, reducing it additionally below the required standard is what triggers the problem of this project.
Was it done with subdivision approval from the planning board?
I'm aware of no plan that shows that. It was just a conveyance by deed.
And is there a house to the right?
Yes. This is the house at 185,
Okay,
and the house for 189 is approximately here.
okay.
But those are the only two plans I found for the property. I don't believe there was ever a subdivision plan or an A&R plan for that conveyance in 64.
Well, who made up the plan that said parcel 1 and parcel 2?
That was done after the fact. That was done later on, not at the time of the conveyance.
That's registered property, right?
No, only my client's is registered property. The subject property is not.
I see.
So this was done in 98 to show that the house encroached?
Yes, the record plan for the locus that shows the parcel 1 and 2 was in 1998, so well after all of the transactions.
Okay. Thank you. Your microphone.
Thank you, Mr. McCarthy. I have to disagree with my brother. The cases that Attorney Reed refers to of infectious invalidity are infectious invalidity. I think, Mr. Gentleman, you're clear as to what that means.
Yes.
It means that if you take land away from one piece of land to make another piece of land or to add another piece of land, if you make the donor land non-conforming or more non-conforming, that invalidity translates to the land that the land is added to. Except here's the difference. Those cases all involve taking land from one piece to create a buildable lot. Meaning, you're taking some land off of this piece and this piece to create a lot that you can pull a building permit and build a new house on. And the Spooner case and the Potnut case involved those particular transactions. This is not that situation. This is a situation in which you have one house that we're talking about now built in 1950. You have the parents' house at 185 built in 1900. What you're doing is you're just shifting a lot line between the two properties to address this encroachment issue as you saw on the plan. So you're not creating a piece of buildable land. You're not creating a new lot or a new home. That's what makes this different from the reported case law that Mr. Reed is referring to in the infectious invalidity situation. So I don't think the case law applies. The concern is that you're going to cobble some land here and some land here and put a new house up. That's not what happened. So I don't believe, and it's my opinion and it's my presentation of this board, that the doctrine of infectious invalidity doesn't apply here because it wasn't to create a new lot, to intensify the neighborhood in that type of development. So,
Pardon me, where the intent here you're saying was to remedy an encroachment or
That's conjecture on my part, Mr. McCarthy, but I think my brother alluded to the same thing, which is that when you look at that plan that is Exhibit A, it looks to me as if that piece of land was conveyed to move that boundary line south to make sure that encroachment onto the parent's house was cured in some way. But when you look at the two properties as a whole, it doesn't change the two properties. You still have two single-family residences. They're both on non-conforming lots, I believe, and I could be wrong by about 102 square feet, both on non-conforming lots. The lot coverage of the two structures is what it is. You're just changing the boundary line between the two properties, not creating a new buildable lot. So I don't think that the doctrine applies here. So I think that this property retains its non-conforming status and it's eligible for a special permit. But obviously, this board has to make their own findings as to whether or not this is a properly non-conforming property that's eligible for a special permit. And I think that before you go to address the merits of the application, you're going to have to consider that element of the application. I'd also like to be heard on the issues of the property owned by the abutters. I'm going to present to the board two plans, and let me just give a copy to Mr. Reed as well. And these plans are photocopies taken from the town GIS website for the property. The first one is and I'll just scan them if you don't mind.
Yeah, we can share.
The first one is the assessor's map, and if you could, for the property. And what I've outlined in orange are the properties owned by the abutters. You'll see the largest one, which is up along the bay, is that large piece of land that abuts the applicant's property. The applicant's property has the number 189 on it, and you'll see that it encroaches right up against the Buckley property. The second map is the GIS filter showing wetlands. And so when you look at this, let me see if I get this the right way. I always forget which way I have it.
Mayflower?
Yeah, right here, 189 is right here. And what you're looking at with this map is, it shows the cranberry bogs. And you can see 189, and you can see the applicant's property right here, and you can see this. And when you look at these properties, you'll see the nature of the wetlands and the nature of the property that's being accessed and owned by the Buckleys. Further, I'm going to present a photocopy of the online accessible database showing ownership of the properties. And this is just simply a name search under Buckley to show properties owned. And this is the information that I use to outline those properties. It's possible they may own other lands under different names. But you'll see when you look at this list that the property that's located at 10 Wildflower Lane has an assessed value of $5,060. That's a piece of land that's assessed at having 8.1 acres of land. That's the assessor has determined that to be 8.1 acres, which gives you some indication of at least the assessor's opinion of developability. When you look at, and you'll note when you look at the assessor's map, the one that I've drawn the orange on, you'll notice that the access to this property is over Wildflower Lane. You come in from Skakit Beach to Wildflower Lane, and then you enter the property. But when you look at the engineering plan that was presented by Ryder Wilcox, which is the site plan, the Ryder Wilcox site plan, you note that the Ryder Wilcox site plan has identified the wetlands distances on this plan. And when you look at this plan at the bottom, right where that encroachment is that we've been talking about, you'll see that there's a line that says 75 feet from edge of dune, 100 feet from edge of dune, and then shows a dune area at the top. In the wetland at the bottom, you'll note that the entirety of the right-hand portion of the Buckley property is within a resource that would be governed by the Conservation Commission. So even though Attorney Reed is saying that this property may be developed